Welcome to the I Got Fired podcast for people who've been fired or afraid that they might be. I'm Tom Spiegel, founder of the Spiegel Law Firm. We help people who've been fired or afraid they might be in Virginia, Maryland, and Washington, D.C. A little bit of legalese before we get started. This is not intended to be legal advice for your specific matter. If you want specific legal advice for you or an attorney-client relationship, you got it. You need to go consult with a lawyer. Now, that said, we are going to continue our series today on the litigation process and the steps in the litigation process. We've already talked about, kicking the litigation off by filing a complaint, getting the answer back from the defendant or a motion to dismiss. We've talked about extensions when the other party or you ask for an extension of time. We've talked about the first stage of discovery, where we call it the paper discovery, where the other side and you as the plaintiff, usually the plaintiff, if you are an employee, you get to submit questions to the other side, and they get to submit them to you, and you get to ask for documents, and the other side gets to ask documents for you. And we touched briefly on the fact that there may be disputes during this time and motions to compel to get that information. So now we're moving to the second stage in the discovery process and the final stage, and that's where we get to depositions. And for those of you who are checking out the rules of federal evidence, this is Rule 30, which is the primary one which governs depositions. Well, what are depositions? Depositions are when either side gets to take testimony, oral testimony, relevant to the case. So it's almost, you're not in court, but it is the next step to being in court. You've got generally a court reporter there who's taking this down just like they would in court, and you're there, or your witness is there, the other side is there, and you are not, there's not a stand in the sense like you get put on the stand in court, but it is somewhat like that, and that there are going to be a series of questions asked by both sides. And this is, as a practical matter, really where the rubber starts to hit the road. Yes, it's gotten, of course, serious by now because you filed a complaint. This is now public record. Anybody who wants to see it. There have been papers, back and forth. Either side now probably has notebooks full of documents that have been sent from the other side and answers to the questions that you have asked. So the case is really starting to get some meat on the bones now. It's beyond, assertions made in the initial pleadings or in motions. You've started to kind of put your money where your mouth is at this point. But it can be expensive for both sides. Particularly if you're having disputes over documents being turned over, and you've got motions to compel, which require court appearances. But it's not nearly as time intensive generally as depositions, because depositions can, and again, a lot of this will be, you've got Federal Rule of Evidence 30, but you've got your usually a court schedule prior to depositions, which will outline how many depositions can be taken. Usually for a single plaintiff case, it's rare to have, more than 10 depositions per side taken. It's usually a lot less than that. How long they're going to be. Typically, the time limit is 7 hours for a single deposition. And the time frame which these are going to happen. So, discovery, discovery is going to close on X date. So, everybody has to get your depositions done by this time. And that's a court schedule. So sides can't just agree to move that. You can get those dates modified, but you have to file a motion. So at this point, this could be the first time, unless there's been extensive mediation in the case, this could be the first time where you really get to see some of the key performers from the other side, whether it's your former boss, somebody from HR, it could be somebody from the C-suite of the company, like the CFO. It could be even the CEO of the company, right? You can, it's not just what we call parties to the litigation. So it's not just you and the company that or the person that you are suing. Either side can depose people who are not part of the lawsuit. I mean, they may be witnesses, but that you can subpoena them to show up to these depositions, and these subpoenas can be court enforced. So it is serious business, and this is when both sides are really starting to get a look at the other side's testimony. And generally what happens is that before the deposition occurs, a notice is sent out. If you're a party, by that I mean you're named in the lawsuit, you don't have to subpoena them. If it's a non-party, generally you do subpoena them to show up for the deposition. And the notice of the deposition basically says it's going to be at this time, it's going to be recorded by a stenographer or a court reporter, and it's going to be from this time to this time. So the notice goes out, maybe the subpoena goes out, and then the day of the deposition comes. And like I said, this is, it's like being in court. It's not in court. I mean, you're not going generally to the courthouse, and you're certainly not in a courtroom. This is, in most cases, one of the offices of the lawyers, or the deposition. There are a bunch of companies now that will provide space for both sides to come in and do depositions. But it's going to be in some conference room, perhaps windowless. So while there can be a lot of heat, it's not, the public can't come in and watch these. So it's going to be just you, your attorneys, and the other side, and you're going to be in some conference room. There'll be a court reporter there. The party who has noticed the deposition will provide the court reporter. This is another area of expense because you obviously got to pay the court reporter for that. So, in the DC area, if you've got a full day of depositions, it can be anywhere from $700 to $1,000 if you're going the full day with that court reporter. But the court reporter will be there with the funky little keyboard, and he or she will be taking testimony. If you are the witness, or any witness, but let's say it's you, then you'll be sworn in. This is testimony under oath, again, just like you are in a courtroom. But let's switch it. Let's say it's the other side, and let's say you're taking the deposition of the HR director of your former company. Then the HR director will be sworn in, and the deposition will start. Also, I should add, you can also ask the other side to bring documents. This is particularly helpful if it's a third party. So, when we're talking about paper discovery, it's generally not to non-parties. You're not sending interrogatories and requests for production of documents to people who aren't named in the lawsuit. So if there are documents you think that this witness has, you can request that they bring those documents with him or her to the deposition. So you've gotten to this conference room, everybody's set up. Usually it's like some food is provided, you've got breakfast, something like that. And it's high stress, and it can be a bit awkward because the enemy is there, right? You walk in, they are there, the attorney is there. I mean, this could be, depending on who it is, somebody who you have previously had a long professional relationship with, and now they're here in a deposition. So you should just be prepared for that. Most often, I mean, almost in every deposition, you're going to have a court reporter there taking the transcript of the deposition. They can also be videotaped. They do not have to be videotaped. A lot of times people will do that for key depositions. And again, that will be in the notice. So you don't walk in there and you're surprised by the videographer. It's going to be in the notice of deposition that it's going to be recorded by a stenographer, and there's going to be a videographer there. And again, the party who's taking the deposition is responsible for providing that videographer. And the videographer, it's just like if somebody you might hire to do your wedding. Often they specialize in this kind of work, but they've just got a camera, maybe two, and they set them up and hit the record button, and the deposition starts. Now, one thing to note that is different from trial is that the rules of evidence the rules of evidence which govern what kind of information, what kind of testimony can come in at trial, they do not apply in depositions. So there are very rare circumstances under which you can refuse to answer a question. There are some, if they ask you to share something that you told your attorney, that's attorney-client privilege. There can be other privileges that may apply, but they're pretty narrow. So, if the other side asks you a question, that you've got to answer it in some form or fashion. Now, your attorney can object, and he or she often will, and will object throughout the proceedings, but that doesn't, unlike a court where the objection is ruled upon at the time, and if it's sustained, then you don't have to answer the question. Except in the limited circumstances I talked about, your attorney can say, objection asked and answered, and in a court that might get sustained, and you don't have to ask the question. In a deposition, you have to answer those questions. You will hopefully get a lot of a lot of prep from your attorney. There are, for instance, if you are the one being deposed, you don't want to volunteer a lot of information. You just ask the question. You just answer the question. That's it. Were you there at this day and at this time? Yes, I was there. You don't say, yes, I was there, and the reason I was there was blah, 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 and provide a lot of information that you don't need to provide. You just ask the question, and your attorney should be working with you up to that point, and you'll see the other side doing this as well. So this testimony, I said the court reporter is going to be there. There'll be a transcript of this, and it can be used at trial. It can certainly be used in the motions for summary judgment and oppositions to those, which we'll be talking about next time. You get pages from that transcript. Let's say in the summary judgment motion, your employer might say, plaintiff admitted that she was unsure if she had been harmed by this or whatever, and they can then cite to your deposition and even attach that page of the deposition to the motion. That's perfectly acceptable. They can also be used at trial. Again, they are subject to the rules of evidence at trial. So just because you got asked a question in a deposition doesn't necessarily mean it can be admitted at court. But if it's within the rules of evidence, then it can be. And also the video, right? That's one reason that people take videos, because obviously it's very powerful. If, it's one thing to read a cold transcript of somebody testifying. It's another to see them, particularly if they're struggling with a question, if they're defensive, in the same ways that you would see somebody, on a witness stand, where you would look at them and try to tell whether they're telling the truth. There's a lot of nuance there. So that's one of the reasons that a lot of times people will videotape depositions. Again, these aren't free. It's a matter, particularly if you're paying for the litigation, it's a matter of strategy about whether or not you take videotape depositions. Can you afford that? Is that the best use of your resources? But those are all issues that you can talk to your attorney about. Sometimes depositions are deadly boring. Actually, most of them are fairly boring. They're not a lot of fireworks, particularly if it's not, it's a third party. It's somebody who's not, maybe they're a witness, but they're just, they're there to provide just a couple of pieces of information. The deposition can just be a couple of hours, and there may not be a lot of fireworks. If it's the parties involved, for instance, if it's you, if it's the representative of the other company, sometimes things can get tense. There you can orally file a motion to compel in the deposition. Again, I wouldn't say it's rare. It doesn't happen in most depositions, but if there is that dispute, you can get the judge on the line to resolve this dispute. Judges hate these, but they will do them, and you may see that happen during the course of your deposition. So, and they're, of course, time consuming. Not only, certainly the deposition itself is very time consuming, but the prep for it, particularly if it's a significant deposition, let's say it's your deposition, then you're going to be hopefully spending a lot of time with your attorney reviewing, you're reviewing your complaint, reviewing everything that you said in your interrogatories, reviewing what the other side has provided, because if the opposing counsel is any good, he or she is going to have done their homework, and they're going to come in there with a binder of documents, or maybe it's on their iPad, that they're going to ask you about. They can ask you anything about the lawsuit. You said this in the complaint in paragraph 16. What's your basis for for claiming that? You've claimed in paragraph 34 that you've been subject to emotional distress. Explain to me, how you experience that distress. What does that mean to you? And really drill down on it. Expert depositions can be really interesting and really impactful. So if you have an expert, let's say this is an age discrimination lawsuit, and you were fired at 55, and you've argued that, you are entitled to, front pay, not only back pay wages, but front pay wages of 2 years. And you've got an economist who's going to come in and say, yeah, I'm a PhD economist and I've looked at this, and for his particular field, it's very, the the economy's terrible. These jobs are going away or being replaced by AI, whatever, any number of things that an expert could testify to. Then the other side can depose that expert and can ask him or her about that opinion, can ask him or her about their qualifications. And those can be very lengthy and very impactful depositions, because both sides are going to come with binders of documents. Because if it's your expert, then the other attorney's coming in to try to poke holes in your expert's opinion, or lay the basis for poking holes in your expert's opinion, at trial. For instance, like let's say you're again, this is economist testifying in an age discrimination suit, and they're applying a particular economic theory to make the analysis, and that's where he or she got his PhD in this particular theory, and then maybe the other side comes in, and there have been other academics who have criticized this theory. Then that can be a subject discussion at the deposition. So that's generally how they work. There can also be for when you are taking the deposition of the other side, if you're suing a company, something called a 30B6 deposition. And that is where you send a notice to the other side, to the company, and you say, I want you to designate somebody, sometimes it's more than one person, to come and essentially speak for the company on these topics. You have to lay out the topics beforehand, and those can be subjects to dispute. But generally, we're going to take a 30B6 deposition, and I want you to send somebody from corporate who can talk about, the company's procedures for, handling expenses. That's just an example. And the other side has to find somebody within the company that has that knowledge. Sometimes it's one person, but again, it can be more than one. And that person comes in and testifies as the company, not as me, the person, but I am representing the company in this matter. And it's the other side's duty to prepare him or her to be able to answer those questions. You can then also ask that person questions as an individual, but you generally have to make that clear during the deposition. So again, you can have 30B6 depositions where you're asking the company to send a representative to testify as the company. Not me, Tom, as the HR manager, but now I'm Tom representing the company on this matter. And that can be a really effective technique in employment lawsuits, particularly for the employee, to get the company in there on record. So again, these depositions, they can take anywhere from an hour to 7 hours. Sometimes it could go longer than 7 hours if there are lots of breaks in between. There can be often are arguments during the deposition. You may get a judge on the phone somewhat. Again, it doesn't happen in most depositions, but it's not uncommon. Get the judge on the phone to rule on various motions. It's not uncommon for there to be surprises, right? Particularly if you've asked for documents, or sometimes the other side will show up, and hand you kind of an affidavit from the other side that this person has written to kind of throw you off guard, and to kind of try to suggest which questions. All kinds of games that are played, and again, they can be pretty perfunctory and short, or they can be full of fireworks with a lot of disputes going back and forth. And it's really where at this point, again, this could be the first time, if let's say the other company has designated an expert. Let's say you have submitted your own expert on emotional distress damages, and it's a psychiatrist. Well, the other side can get their own expert to come in and to testify as to why this, why your theory of what this or your argument that you have experienced this severe emotional distress is not supported by the facts. And this is the first time you get to see him or her. Again, it's one thing to read this expert opinions report. It's another thing to see them in action. I don't know if you guys know the famous movie, My Cousin Vinny, where there's, I forget the character's name, but he's the other guy, right, who's being prosecuted, and he's got this attorney who seems like he's really got it going on, very smooth, and then he gets up there to start asking questions, and not a criticism of people who stutter, but he has a very bad stutter, which makes him not particularly effective on cross-examination. And again, before that, he presented as somebody who was, smooth, well put together. And the same thing can happen to depositions. You get, the cold record, and you look at somebody and you say, wow, they're really impressive. And you get them in a deposition and they just fall apart. And then the other side can happen too. You can get somebody in a deposition who is really impressive, and they're going to be a substantial witness. And this is this again could be the first time that you and your attorney are getting a look at these folks. And it's true of the other side as well. This may be for the deposition. It may be the first time that the attorney from the other side gets to see you. And that's why a lot of times employers are really keen to get your deposition if you're the plaintiff first, right? Because they want to see how you react, how you present. Because again, they've seen your answers in the interrogatories, they've seen the complaint, but you've had time to think about these. You've been able to work with your attorney on these, and this is the first time that you have to, show up and perform, and they get to, see what you are like under pressure. So that's why it's important, for your deposition as the employee, that you are well prepared, that you've gone through everything, that you've worked with your attorney to try to eliminate those surprises. And look, you're going to have nerves the night before. That's perfectly normal. It's the best you can. Try to get a good night's sleep. Bring with you, if you whatever comfort food you can fit in your purse or in your briefcase. If you need a particular kind of gum or whatever it is that you need, a protein bar, bring those with you, because you're going to need to keep your wits about you throughout the day. So that's generally how depositions work. Again, this tends to be one of the meatier aspects of the litigation process. It's where both sides are investing a lot of time, a lot of money, a lot of resources. And this is really when folks get to see, sitting across the table, how some of the other side's key performers might react at trial. So, and again, as with any other stage, cases can settle, during this point. It's not uncommon if, let's say, the defendant, it's not uncommon, an employment lawsuit where you, the employee, have sued the employer, they're just, I won't say necessarily rope-a-dope, but they're not taking it super seriously. They're not super exercised, even after you've sued, even after the paper discovery. They're really waiting for the deposition. And if you give a really strong deposition, then, it's not uncommon for the other side to be like, okay, let's talk about settlement. And it can go the other way too. If you have a witness on your side, let's say you've got a really good expert witness and he just really flames out in the deposition, then that can hurt your chances for settlement. So again, like with any other stage, settlement can occur if there are kind of key moments during those depositions, and it's not uncommon for those to happen. So at this point now in the series, we have reached the end of the discovery. Again, and the deposition, let me back up and talk about timeline. If this, let's say it's a discrimination lawsuit that's in federal court, you've had to file at the EEOC first. There may have been some back and forth before you even get to the EEOC. You've got to give the EEOC at least 6 months. By EEOC, I mean the Equal Employment Opportunity Commission. You've got to give them 6 months to even, to consider your case before you can even ask for a right to sue. Sometimes it can take them a while to issue that. So then it can take some weeks, sometimes months to get the complaint filed. It takes 2 or 3 months perhaps to get that answer returned and motion to dismiss decided. You've got perhaps another 3 or 4 months if it's moving quickly. Some courts are very slow, but in the Eastern District of Virginia, where we handle a lot of our cases, it's called the Rocket Docket. They tend to be faster. You could have a couple of months for paper discovery and then a couple of months of depositions. And again, there can be fireworks there. I mean, I've certainly had cases where shocking things have come out at depositions that really sort of turned the tide on the case. So they really can make or break a case at that point. So you're now, at least a year, probably a year and a half, maybe even a couple of years in at this point, and both sides are really now invested in the case. They're getting some witness testimony under oath, and the case really starts to take shape after this deposition period has ended. And what that's ended, then generally discovery is closed, right? Like the facts are out. Both sides have had to disclose what they had to disclose. There have been depositions. There's no more fact finding. And so whatever has come out at this point is what you have to work with at trial. So that is the end of the discovery process. The next time we'll be talking about the summary judgment process and oppositions to summary judgment. And then after that, we'll be talking about the next stage, which would be trial. I hope you found this helpful. If you'd like some more information, about cutting edge employment law issues and also how to keep your career on an upward trajectory, check out thecareerrocket.io. It's our site where we will weekly share with you an email about employment law topics and other suggestions and tips on how to make the most out of your workplace experience. And as always, if you found this useful, if you can give us a comment on whatever site you're listening to this on, it helps people find us. And good luck out there. We'll talk to you next time.